justice is indivisible. Injustice anywhere is a threat to justice everywhere.
We won't relent. We will fight until the end. We have been sent to protect and to defend. We won't relent. We will fight until the end. We have been sent to protect and to defend. Let justice flow like a river, flow from the peaks to
Good morning. Good morning this Monday morning on the 24th of February 2025. And on this particular day, or rather this particular morning, we'll go into discussing the introductory session to alternative dispute resolution in Zambia. And as we get into this very interesting lesson, I implore you to keep an open mind and really try as much as possible to learn from this session. You are permitted to ask for these slides, although they are very much summarized, but we can get a few things from there. Just communicate with my team and I on the provided contact for communication. And for those who are in this course or we are tutoring, you are able to get access to these slides from your class groups. Okay. Now, what is alternative dispute resolution? What does it deal with? So as a way of foundation, we ought to note that when it comes to the resolution of disputes, the primary body established to handle disputes in any country is the court system. So what we will continuously refer to as the traditional litigation system. Every country has a system of adjudicature which exercises adjudicatory functions or the adjudicatory power of the government. This is evidenced in various considerations. Of course, taking into account that there are constitutional countries and those without constitutions. And for those with constitutions, their respective constitutions will provide for this establishment of the system of adjudication and confer upon this particular system adjudicate upon matters that happen between persons, that is either natural persons or artificial persons. In the court of law, there has been these systems for whatever reason, that are used by the parties in the court of law to resolve their matters without involving the traditional litigation, These mechanisms are what we refer to as the alternative dispute resolution mechanism. Now, in order for us to understand ADR, we have to appreciate two important concepts, that is conflict or dispute, and dispute rather. A conflict is defined as a manifestation of differences working against one another, which have ingredients. The differences are inherently exist between the parties or persons in conflicts such as cultural and value differences, interests, beliefs, and patterns of behavior. This manifestation of differences is what we're referring to as a conflict. A dispute has been equally defined as basically a situation or circumstance where two parties hold contrasting views with respect to their interest on a particular subject matter. In order for alternative dispute resolution to be invoked, there is need for a dispute to be in existence or a conflict of interest. The term alternative dispute resolution is an umbrella term that is used to refer to techniques, mechanisms, or methods that are employed by conflicting parties or parties to a particular dispute in an effort to resolve the conflicts that exist between them. ADR, as a matter of principle, was not meant to, or rather is not meant to replace the traditional court system, but rather it is meant to supplement the court systems. Court systems around the world have been struggling and are still struggling with the issue of backlog of cases or the dragging of cases, where cases take way too long for them to be resolved. And as a matter of common sense, we can basically arrive at the conclusion that, especially in the corporate world, corporate entities will either end up losing a lot of money during the court system, or we spend a lot of time during the court system, the court process rather, of resolving the dispute. And because of this, there have been, or rather they've internalized in their transactions, these alternative ways of resolving the dispute that may exist between the parties. Now, what could be the justification for ADR mechanisms in Zambia? Where do we find our footing insofar as these systems are concerned? Article 118, to start with, of the Constitution of Zambia, Amendment number 2 of 2016, confers adjudicatory powers upon the judiciary of Zambia. But in addition to this, Article 18.2 prescribes that ADR mechanisms or alternative modes of resolving disputes shall be exercised or used for the resolution of disputes. Article 118.2d is the constitutional foundation for all ADR mechanisms in Zambia. Of course, this does not denote that before this particular provision came into existence, then we didn't have ADR mechanisms, but rather that the reformation of a constitution to reflect the recognition of ADR mechanisms is an indication of the approach that is being taken, not only by the court systems themselves, but the legal framework as it stands in Zambia and other regions where they are embracing these alternative ways of resolving disputes. Article 118.3 prescribes for limitations of these mechanisms. That is, they cannot be used where the matter in contention has to do with the contravention of the Constitution or the Bill of Rights, where the resolution itself is a contravention of the Constitution, for example, as was in this particular case, rights that are conferred upon the parties using written laws. And as is already reflected in on the slide right now, Section 5 of the Industrial and Labor Relations Act specifically was cited by the arbitrator when they were resolving the dispute. This was in fact a contravention of this prohibition that is found under Article 118.3, specifically Article 118.3 3b. Now, with that said, we can come to the conclusion there has been several reforms are encouraged to be used in order to ensure that there is effectiveness and efficiency in the resolution of justice, and aside from that, that there is a resolution of dispute in a very timely manner and very convenient manner in respect to costs. The general framework, of course, there is an extension of the framework that regulates ADR mechanisms in Zambia, due to the fact that there can be an existence in an arbitral clause of referring maybe the applicable law to another state, rather. That means that the framework is extended, or that it might be that the clause itself elects to apply maybe two or more laws in the resolution from two different jurisdictions in the resolution of a particular dispute. That in itself extends the framework. But generally, the following make up the legislative foundation for alternative dispute resolution in Zambia. Firstly, we have the Constitution of Zambia. It was indicated already that Article 118 recognizes that ADR mechanisms should be used in Zambia. This provides for the foundation, as I have already alluded to. Then, in addition to the Constitution, we have legislation. There's so many legislation that are present in the Zambian legal framework that talk to ADR mechanisms. The High Court Act prescribes for moments of intervention. Of course, this is read together with the Arbitration Act, which prescribes that the High Court can set aside a judgment, or rather an award, that has been given by an arbitrator. So in circumstances where there's suspicion of, say, impartiality on the part of the arbitrator, or where the arbitrator exceeded his authority, the High Court is the first court that will be able to handle this particular matter on an application to set aside, because there is no appeal process in the arbitration process, as we will learn later on. Aside from this, we have the Industrial Relations Court. The Industrial and Labor Relations Act. The Industrial Labor and Labor Relations Act prescribes for one other mode of resolution, which is conciliation. Aside from this, common law and equitable principles are applicable in the resolution of disputes that arise between the parties with reference to ADR mechanisms. And then there's also international law, such as the Unilateral Model Law or the United Nations Convention on International Trade Law, model laws and rules on arbitration and conciliation. These model laws help guide the courts in circumstances where there has been, say, a lacuna or a missing portion when it comes to regulation. In fact, the Arbitration Act itself adopts the model law to be part and parcel of its text at the back of the legislation. Now, since we've laid the foundation for the legal framework, what could be next? Why ADR and not litigation? Why would party opt to go for alternative dispute resolution and not litigation? Number one is party autonomy. What does this mean? It basically means that the parties to the dispute have got some form of choice to exercise in the resolution of the dispute. One such example of party autonomy is the privilege that is given to the parties to elect their adjudicators. So unlike in the court system, where judges will be appointed to hear your matter, in alternative dispute resolution, you will have the right to appoint your own adjudicators or mediators or conciliators, depending on the system that you've selected. So, as an example, arbitration, you may have it in the text of the arbitration clause that either party will elect one arbitrator to sit on the panel, and the other panel will be elected by the two that have been chosen. So this gives liberty to parties to participate in the appointment of arbitrators, thus emphasizing on this particular point of party autonomy. Secondly, ADR mechanisms, or the use of ADR in the resolution of disputes, is less expensive in terms of costs and time. To emphasize this point, Section 4 of the Statutory Instrument Number 73 of 2018 provides that this mechanism, that is court-annexed mediation, should be concluded within 45 days. This places a time frame for the resolution of the dispute, unlike in the court structure, where in respect to time, the days are not ascertained in most cases. So this is a very huge contrast, and parties would want to have their matter resolved in a very time frame, unlike spending a lot of time in the court system and not focusing on, for example, if it is a business, in the business itself. And then when it comes to costs, specifically with respect to costs, if you compare alternative dispute resolution and litigation, maybe from a commercial standpoint, the alternative dispute resolution is more favorable as compared to litigation. Thirdly, there is guaranteed confidentiality. The general rule when it comes to the resolution of disputes in litigation is that the matter should be held in public. That is, it is not supposed to be held in camera. But because the dispute that usually arises between the parties who have inserted this type of a clause electing this type of resolution is one that will be restricted to the parties, there is the promotion and guaranteeing of confidentiality, as only the parties to the cause are allowed to participate or even hear the matter itself. Not necessarily participate, but hear the matter itself. Whilst as compared to litigation, anyone can just walk into the court and sit there and listen to what is going on. So there is guaranteed confidentiality when it comes to ADR mechanisms. Fourthly, unlike in litigation, it is not a win and lose situation in ADR mechanism. Most of the mechanisms focuses on the resolution of the disputes between the parties in order to reach an outcome that is favorable for both of the parties, thus creating a win-win situation. In litigation, as contrast to generally ADR, what is focused on is the rights of the parties. So what is going to happen is that in litigation, it will be the institution, the right of the parties. But when it comes to ADR mechanisms, they are going to resolve the matter, which is going to provide for a win-win situation for both parties. The first is the exception for arbitration, which is constantly focused on the rights of the parties, and like the particular business in the doing about that particular outcome. Number 5 is expertise movement. ADR mechanisms requires experts rather in their respective fields to sit on these panels in order to resolve the matter. Of course, there's no one size fits all when it comes to the ADR mechanism. As others are experienced or well vested in certain mechanisms of mediation, and in addition to that, it means that they have some level of expertise in the field of engagement. As a way of example, it could be that one is the instruction itself, and what we call design alternative dispute resolution, then that will be guaranteed that when they are put upon to help resolve the matter, they will not only apply the principles that they have learned from most of people who are part of this particular mechanism or without the other people that are collaborating are one of the experts, the expertise of their respect. It could be an expert in the medical profession, it could be an expert in the legal profession, the construction industry, and so many others. So this is a guarantee that is put there. The court system, it could be that you are even assigned a judge that is not well vested in terms of expertise in the area under analysis, but because it considers a judge in a particular court, they will usually look at things from a general standpoint or with the aid of an expert. But when it comes to expertise in insurance, lastly, maintenance and operations. Because the ADR mechanism is what is focused on the resolution of the dispute written about a win-win situation, most of these business relationships that take this route are maintained and they are reserved. Unlike going into litigation where one is going to declare the winner and the loser for lack of a better term. So these reasons or these justifications or these things that have noted down provide for some form of justification as to why parties may prefer using alternative dispute resolution as compared to litigation. Okay, moving on. Now, we've been talking about alternative dispute resolution mechanisms from a very general standpoint. Now, what are some of the basic forms of ADR mechanisms? Number one, we have what is known as negotiations. Now, by way of definition, a negotiation is a fundamental procedure entered into by parties to a dispute with a view of settling their disputes without the involvement of third parties. So, as the word itself has indicated, this is where basically parties come together and they discuss a way forward in order to handle the dispute that has arisen between them. And in these kinds of setups, they rarely rather involve third parties. In international law, they usually do this maybe through their diplomatic channels, or it could be through their diplomatic envoy. At the end of the day, the point is they come together and they negotiate. They basically discuss the challenge that they have faced or the dispute that they have encountered, and each of them give their respective positions on the matter and what they suggest could be the best solution to handle the case. And this is where things such as the best alternative to a negotiation agreement, the BATNA, comes in, or the WATNA. So these are going to be presented, and at the end of the day, if they manage to resolve the dispute, there's going to be an agreement that is going to be formed for the purposes of resolving the dispute that has arisen between the parties. So this is usually the first step that is taken by parties, either in a local aspect or in the international aspect, to resolve the dispute that has arisen between them. And if this doesn't work, they usually go to other modes of resolving a dispute. Otherwise, this is the basic step that is taken by most parties, unless where negotiations are impossible to facilitate. Then from negotiations we go to mediation. Now, unlike in negotiations, in mediation there's the involvement of a neutral third party who is called a mediator. So mediation, by way of definition, is a process in which a neutral third party, either an individual or a company or presidents in international relations, is selected by the parties to the dispute, who aids them in their settlement discussions and attempts to have the parties negotiate a resolution of the dispute. So it is like negotiation, but this time around, there's a third party who is intervening and who is trying by all means to provide for an answer, or rather to provide for a channel that parties can take. Not parties would that not parties must take, but parties can take and may take, because the opinions or the directions of a mediator are not those that are binding on the parties, but rather they provide for some form of guidance, thereby trying as much as possible to bring the parties to reach a compromise that is going to give them what they want out of those negotiation processes, but at the same time equally resolving the dispute and not making one win the matter over the other. There are three recognized ways of facilitating for mediation. Firstly, it is through a mediation clause in a contract. So where parties have chosen to include in their contract not a clause that is relating to arbitration or any other mode, but to mediation specifically, then the parties can opt to go for that particular mode of resolution. Then secondly, it is where parties have chosen to abandon negotiation processes. So for example, in circumstances where negotiations have commenced and the parties have noticed that they are not addressing the problem and they need a third party to be involved, they can opt to abandon those negotiation processes and take their matter before a mediator, and the mediator is going to help them come to a conclusion. Then lastly, there is what is known as court-annexed mediation. This is usually prescribed by the courts of laws themselves. So you may go before the subordinate court, or you may go before the High Court here in Zambia, and using those two statutory instruments that is shown on your screen, that is statutory instrument number 173 of 2018 and 172 of 2018, the courts can actually direct that the parties go to mediation, unlike going through the entire litigation processes. There are justifications that needs to be looked into for this to be prescribed rather by the courts themselves, and we are going to delve deep into all that when we do mediation as a separate topic. But by way of introduction, we should have it at the back of our minds that there are three ways in which a mediation can be facilitated: through a mediation clause, where parties choose to abandon negotiation processes, and court-annexed mediation. Moving on, we have what is known as conciliation. Now, conciliation is a recognized legal alternative method of resolving disputes here in Zambia. Conciliation is reflected in the Industrial and Labor Relations Act. It is reflected in the Industrial and Labor Relations Act. This act defines conciliations in the following way under Section 2 of the Interpretation section. Conciliation is defined as a process in which a third party, called a conciliator, assists parties to a dispute in reaching a mutually acceptable agreement. The conciliator does not have the power to impose a settlement, but rather facilitate communications between the parties and help them identify common interests and potential solutions. Now, in most cases, this is opted for where the communication between the parties have gone sour, or in cases where it is very likely that there's going to be a particular individual or person who has other than conciliation, we have arbitration. Arbitration is the biggest process that we're going to consider in this course, and uh, this is due to really its position and its use as compared to the other systems or other mechanisms. This is the mostly used and mostly regulated here in Zambia. So we're going to look into this because conciliation, specifically conciliation, there isn't really a proper regulatory framework. Just like there is no regulatory framework that regulates construction adjudication. Now, moving on from that, arbitration. What is arbitration? By definition, it is basically just a process where a dispute is put to one or more neutral third parties chosen by the parties or an institution for a final, binding, and enforceable decision. Now, unlike the three that we've considered, in this case, the arbitrator or the panel of arbitrators can make a final, binding, and enforceable decision. What does this mean? It means that the parties will be allowed to make their respective cases, and the arbitrator will now have the powers to make a decision, and that particular decision is binding on the parties. Now, there is no appeal process when it comes to arbitral awards. This is why you'd find that they are actually recognized to be final, binding, and enforceable. So those decisions that are made by the arbitrators are called awards. So when an award has been given, that particular award is binding, it is final, and it is enforceable before the courts. Now, like I said, when it comes to arbitration, there is no appeal process. So the only way one can challenge this particular award or the decision that has been given is when one is making an application to maybe set aside the award that has been given on several grounds. It could be because the arbitrator lacks jurisdiction, or they exceeded their powers, or there was no impartiality. On those bases, if that is rather the justification, then one can actually challenge the award. Otherwise, it is final and it is binding, and one who wins the case can actually proceed before the High Court to proceed to enforce the award. Okay. So in Zambia, the Arbitration Act is a principal piece of legislation that guides on matters relating to arbitration. So you need to have that copy of the Act and the UN model law, which is just behind the Act itself. Now, aside from these four principal mechanisms, there are also other mechanisms such as good offices. There are other mechanisms that are like a combination of two, such as mediation and arbitration. There's construction industry adjudication. There are mini trials. There's private judging, summary jury trials, and early neutral evaluations. All these plus more include or form what are known as ADR mechanisms. So as you go about your day, if you come across any of these names, just know that we're talking about alternative ways of resolving disputes. So unlike going to court, you can just go before these mechanisms. Now, there are recent developments that have been made with respect to ADR in Zambia, and I've just noted down two that will require your attention, maybe as a way of interest. Maybe you can read into them. Now, Zambia in 2024 launched an arbitration center. It is called the Lusaka International Arbitration Center. It is a huge step, not only on indication the country's embracement of ADR mechanisms, but also a huge step in providing for international arbitration here in Zambia and even in the region, because this particular body is not restricted to just handling matters relating to arbitration that are in Zambia. So the institution provides for a platform for people to opt to go to the institution instead of going to court, or establishing an ad hoc that is for the purposes, and a panel that is set just for that particular purpose. So we can now go before an institution, and the institution has got its own rules, it's got administrative procedures and structures. So it is an independent institution in its own, but providing for these alternatives. It is here in Lusaka, and whenever you have time, please visit the center. It's a marvel. It's a marvel if you visit it. Number two is the statement that was made by Chief Justice Mumbamalila this year when he was opening the criminal sessions of the High Court. So he noted on something that really has been in the discussion with respect to ADR mechanisms, and that is the integration of these mechanisms in the criminal justice system. As we'll discuss further, and as I will note further in these lessons, you're going to find that even when it comes to the criminal justice system, there's a way in which one can go before an ADR mechanisms to resolve their matter and not proceed with the whole case. Of course, this is within particular barriers. Now, as a way of closing the lecture or closing this lesson, we have to take note of something. ADR is an embracing phrase, right, that denotes a set of techniques. These techniques or methods are used by the parties to resolve their cases. It is very important because these mechanisms provide for an alternative to the traditional litigation system. Of course, hinting on several matters or several positions, such as that which relates to time effectiveness, that relates to cost reduction, that relates to party autonomy and involvement. All those are benefits or all those are advantages of ADR mechanisms. And then the disadvantages on the other hand, if we had to do that, we can identify things like, because not all of the systems are not really restricted when it comes to time, they may be used as a technique to delay process. So this could equally be a downside. It could be a downside on the part of arbitration or in the part of ADR mechanisms rather, and also it could be an indication that litigation in certain circumstances could be the best option to take. So these are very important considerations that you need to take into account when you're considering ADR mechanisms. And this being our introduction is going to end at this point. When we start the next lesson, we'll start by looking into specific forms of ADR mechanisms. The first two forms that we're going to consider is negotiation
relent. We will fight until the end. We have been sent to protect and to defend. Let justice flow like a river, flow from the peaks to